Let me tell you a story. This is a true story, going back to my first election for the Michigan Court of Appeals in 1988. On the morning after the election, and it had been a long campaign, I was very excited and happy to have won, and I was pretty proud. Little did I know that a huge dignity chaser was about to come my way. I was going up in the elevator to my law office. A 30-ish looking man got on at another floor, and he looked at me and he recognized me and he said, "Oh, my son voted for you in the election." Thinking that the man looked young to have a voting age son, I hesitated before I said this, by the way. But I said, "Did your son just turn 18? And he said, "Oh, no." He said, "He's 8. You see, I wanted to, show him about the importance of elections. And so I took him with me into the voting booth." He said, "Well, of course, first I voted for all the important elections. Then I let him fill out the part about the judges." Unfortunately, that father is probably not alone in his attitude toward the election of judges. Of those who voted, that's a true story, and I've never forgotten it. Of those who voted in the last election, only about 20% voted for the judicial candidates, including 8-year-olds. It's ironic that at the time when there's so much information freely available on the internet, we have that level of interest in and knowledge about the candidates for judicial office. There are, of course, well-informed voters, like the members of the League of Women Voters, and my hat is certainly off to the League and to the other groups that work to educate voters. But it seems those individuals are in the minority. So what is the answer? In a guest editorial in the November 15, 2008 Wall Street Journal, former U.S. Supreme Court Justice Sandra Day O'Connor suggested that the long-term solution to the impact of special interest money is robust civics education starting at a very young age, with merit selection as a short-term fix. Like Justice O'Connor, I would like a world in which every voter is well informed. But for the time being, I think we need to focus on what can be done to improve the system we now have. So here are a few suggestions. First, the legislature should change campaign finance laws to require complete reporting and transparency for those who finance issue advertising and give those laws real teeth. The identity of those groups that sponsor issue ads is often, as you know, unclear and even shrouded in mystery. We should oblige these groups to identify themselves in advertising as well as in reporting where their funds come from. Another area where improvements are needed concerns the disqualification or recusal of Supreme Court justices. As you may know, the Supreme Court is currently weighing proposed rules for disqualification of justices. We have rules about the disqualification of all the other judges, 608 judges in the state, but not for the 7 who are on the Supreme Court. And you may shake your head, as I did when I first learned that, and say, well, why in the world is that so? The truth is, in an effort to formulate such a rule, I've come to realize it's incredibly more complicated than it might appear, and that it is for other judges in the state. But having said that, certainly there's a need for a rule that will allow voters to know something more about these justices, and of course that presupposes that we know where the justices' campaign contributions came from. But in any event, the Michigan Supreme Court must adopt a recusal rule that governs its justices. Next, we must not lose sight of the fact that we already have a system of selecting judges that's very highly appointive, but that lacks rules about those appointments. A governor has free rein to make appointments, and so far, no governor has shown an interest in changing that process. The governor could do it. The governor could institute his or her own system of appointment that would incorporate a merit selection panel. I think that we need a new process for the appointment for those judges who are appointed in this state that involves a merit selection panel. That panel then should advise the governor, and it's from that the list of recommended candidates that the governor must choose. Third, the legislature should adopt an effective system of public financing. The legislature should make it feasible for a quality candidate to run on a level playing field, notwithstanding the effect of special interest group monies. Well, now in summation, I don't pretend, as you can see, and it would be foolish of me to propose to you that there's any really simple solution to these problems, and that there's any one perfect judicial selection process out there. But merely because of that, we cannot retreat from the problems we all recognize exist in the present system. Public confidence in the courts has already been eroded, and I hope that the League of Women Voters will continue to be part of the serious, long-term solution we have to bring to this issue. Thank you.